Good morning, everybody. Welcome to this fifth webinar in our series on Voyage Charter topics. As some of you are aware, we've already completed a series on Time Charter topics, all of which are now available on our Birketts YouTube channel. So today's talk, as you hopefully know, is demurrage. And the first question that we're going to look at is, what is demurrage? Now, hopefully a number of you will have listened to the webinar 2 weeks ago, given by my colleagues Henry and Tom. Now, that webinar covered the topic of lay time, and for that reason, we will not repeat any of that here. But as most of you will hopefully appreciate, the topics lay time and demurrage go together. Now, demurrage is liquidated damages for a breach of charter by the charterers in failing to load and/or discharge cargo within the contractually agreed lay time. That position was summarised in 1920 by Viscount Finlay in William Alexander versus AKT Hansa, in which he said, "If the charterer has agreed to load or unload within a fixed period of time, he is answerable for the non-performance of that engagement, whatever the nature of the impediments, unless they are covered by exceptions in the charter party or arise through the fault of the shipowner or those for whom he is responsible." There's another definition of demurrage which is set out in the lay time definitions for Charter Parties 2013, which is also quite helpful. This says, "Demurrage shall mean an agreed amount payable to the owner in respect of delay to the vessel beyond the lay time for which the owner is not responsible. Demurrage shall not be subject to lay time exceptions unless specifically stated in the charter party." Next slide, please. A charterer's liability to pay demurrage is absolute unless, firstly, there is a relevant exception, or secondly, there is fault on the part of the shipowner that led to the delay. We'll discuss both of those exceptions below, slightly further on in this webinar. It's, however, important to note that liability for demurrage is absolute and does not require any fault on the part of the charterer. There is already fault in that the charterer has failed to load or discharge within the laycan. This is the case even where the charter incorporates the Hague Rules, which appear at its Article 4, Rule 3, to state that a shipper is not responsible for any loss caused without his fault or the fault of his servants or agents. Now, whilst it might be appearing to skip to the end of the lecture, we thought it useful to add a brief comment regarding the end of demurrage. Now, in the vast majority of cases, this will not be controversial, and demurrage will end when loading or discharge is completed. So whilst disputes in this area are reasonably unusual, one issue that can arise is where a charterer refuses to complete discharge, particularly if the cargo has changed in some way from the cargo that was originally loaded, for example, because it's become contaminated in some way. The general principle is that those responsible for discharge remain responsible to discharge that cargo, even if it is damaged, unless it is so damaged as to amount to a change in specie. Now, you might ask how damaged a cargo has to be in order to amount to a change in specie. Now, unfortunately, that's a question of fact, and it's tricky to give guidance. But generally speaking, the cargo must no longer be recognisable as the cargo that was loaded. Now, there's one case on this that always sticks in my mind. It's a case from 1895 that concerned a cargo of dates on board a vessel that sank. Now, that vessel was later raised. I don't know how much later, but when they brought it up, it was held that the dates, perhaps surprisingly, still retained the appearance of dates, and they had a value for the use and production of alcohol. But they were no longer merchantable as dates. I actually believe they'd been contaminated with sewage or something else. Now, because they were no longer merchantable as dates, this amounted to a change in specie. Now, that case is Asfar and Covey, Blundell, and others. Next slide, please, Sophie. Now, exceptions. Many of you will have heard the phrase, "once on demurrage, always on demurrage." For those that are unfamiliar with this phrase, its meaning is that once lay time has expired and demurrage has started to accrue, it will continue to accrue until the end of cargo operations. Now, as with many commonly quoted phrases, this one is true only in part. The rule is relevant as there can often be circumstances where there is a delay once lay time has expired and the vessel is on demurrage, but that delay is no fault of either the owner or the charterer. So let's say there is a fire at the port delaying loading operations. In those circumstances, the charterer may try to say that the delay is not their fault and they should not be liable. Now, whilst this may be true factually, let's say they didn't start the fire, the owners would say that if charterers had complied with their obligation to load during the lay time, the fire would not have impacted the loading operations, as the vessel would have already sailed before the fire began. Therefore, demurrage will accrue. However, the once on demurrage, only on demurrage rule is only relevant in part, as if a charter party expressly provides for exceptions to demurrage, then demurrage will not accrue in circumstances where the criteria of the exceptions are met. Now, interestingly, whilst it's often stated that for an exceptions clause to apply to demurrage, it must expressly state this, i.e. refer to the word demurrage in the exceptions clause, in fact, there's no case law on this point. And if anyone's particularly interested to look at that further, the relevant authority is the Calliope A. Now, despite this, it is well accepted that an exceptions clause must be extremely clear that it applies to demurrage in order to stop time from running. There is in fact only one English law authority that I'm aware of where a clause not expressly or by necessary implication referring to a demurrage has been found to act as an exception. That was in the 1987 decision of the John Michalos, in which the clause in question had to be read in the context of the chart as a whole, in which case it became clearly the exception, which related to strikes, must apply to demurrage, despite it not expressly stating this. Next slide, please, Sophie. Delay caused by the fault of the ship owner. Now, whilst this might appear an obvious point, it's worth making clear that where delay is the result of fault on the part of the ship owner, or those for whom he is responsible, that will act as an interruption to demurrage, as it does to lay time. This follows the rule in Budget and Billington, which I believe was discussed by Henry and Tom in their webinar on lay time. In the Stolt Spur, and I've put the citation for that on the slide, which made no distinction for these purposes between lay time and demurrage, it was suggested that in both cases, so both lay time and demurrage, time will not run where the ship owner's conduct results in the charterer being deprived of the use of the ship, even if no delay in cargo operations results from this action. Next slide, please. As demurrage is liquidated damages, by which I mean damages which the parties have agreed will be payable at a fixed rate per day, there is no requirement that the owner must take steps to mitigate his loss. The demurrage rate will apply regardless of whether the owner's actual loss is more or less than the pre-agreed rate. Now, whilst there is no requirement to mitigate in the traditional sense, there may be an obligation on the ship owner to ensure that delay to the vessel is not unduly prolonged by a failure on the part of the owner to act reasonably. A complaint that's often made in this context is where cargo operations are delayed due to a lien being exercised by an owner. Now, in those circumstances, and assuming that the lien was exercised lawfully, a charterer will generally have no defence to an owner's claim for demurrage, and this is going back to the once on demurrage, always on demurrage rule. However, if the exercise of the lien was unnecessary or unreasonable, now let's say because the owner could have taken other steps to secure his claim while saving time and costs, and one example given in the books is that he could discharge the cargo before exercising a lien, it's possible that an owner could be found to have failed to mitigate. It's thought that this would be a rare situation, and the relevant question is whether exercise of a lien ashore would have saved the owner time and cost. Albeit in reality, it's likely that other factors would also need to be considered on a case-by-case basis. Interestingly though, on the other hand, if an owner takes steps to speed up loading or discharging, and in so doing goes beyond his contractual obligations, and as a result reduces a charterer's demurrage liability, that owner is entitled to recover any costs incurred. Now, an example of this given in a case called Leeds SS v Duncan Fox is an overtime payment to stevedores. Next slide, please, Sophie. You may hear discussion about detention when people are talking about demurrage, and it's worth looking perhaps at the unamended GenCon 76 demurrage clause as a starting point here. Now that clause reads, I've put it on the slide, but I'll read it out for you. 10 running days on demurrage at the rate stated in box 18 per day or pro rata for any part of a day, payable day by day, to be allowed merchants altogether at port of loading and discharging. Now, whilst this clause is rarely left unamended, in its original form, a charterer is only liable to pay demurrage for a period of 10 days delay. Beyond that time, if the vessel is delayed, an owner would have a straightforward damages claim based on ordinary rules of remoteness and causation. Now, that would be a claim for damages for detention, and the claim may be more or less than the demurrage rate. Importantly, the burden of proof in that scenario would be on the owner. Now, that clause that I've just mentioned is an unusual demurrage clause in that the majority of standard clauses, including the 1994 version of the GenCon form, do not limit the period of demurrage. Now, one result of this is that where the vessel is delayed and demurrage is accruing, an owner will not be able to argue that the charter has been repudiated by the charterer's failure to load within the laycan, unless or until the owners can show that the delay is sufficient or will become sufficient to frustrate the contract. Next slide, please. A further point which has recently been subject to scrutiny by the Court of Appeal is whether an owner is entitled to damages in addition to demurrage, where an owner suffers a loss beyond delay to the vessel. Now, up until 2 weeks ago, the authorities were undecided as to what happened in the scenario where the charterer's failure to load or discharge within the laycan resulted in some other type of loss, for example, cargo damage, and that's beyond the delay to the vessel. Now, in the Eternal Bliss, charterer's delay in discharging cargo, and that was soybeans, caused the cargo to deteriorate. The delay was due to congestion and a lack of storage space. Importantly, there was no separate breach on the part of the charterer. The receivers, the cargo receivers, brought a claim against the owners for the cargo damage, which the owners settled at a cost of $1.1 million. The owners then sought to recover that sum from the charterers by way of indemnity. The court was asked to determine whether the owners were entitled to claim damages, so that's the indemnity for the cargo damage claim, in addition to demurrage. So we're going to have a poll now, partly to see who's been keeping up to date on the recent case law. So in circumstances where there was no separate breach, do you think the court found that the owners were entitled to claim damages, so that's the indemnity for the damaged cargo, in addition to demurrage or not? As I say, it's those of you who do keep up to date and have various case law updates, you should have seen various articles about this. Most of the London chambers have published articles. It looks like most of you have been keeping up to date with your case law, so well done there. So in the Eternal Bliss, and there we are, in the Eternal Bliss, and the Court of Appeal judgment was handed down on the 18th of November 2021, for any of you who want to look at it. The court concluded that, and I've put the quote on the screen because I think it's very helpful, in the absence of any contrary indication in a particular charter party, demurrage liquidates the whole of the damages arising from a charterer's breach of charter in failing to complete cargo operations within the lay time. And that's paragraph 52 of the judgment. And I've noted in a couple of the commentaries on this that the sort of references to whether this will go to the Supreme Court. For now, this is the law. I don't know whether this will go to the Supreme Court, but if it does, obviously someone will have another look at this. But for now, that is the answer. So we'll see if this develops any further. If we can go to the next slide, please, Sophie. Now, the Eternal Bliss deals with the question of whether there is no other breach of charter by the charterers. But where the charterer does commit some other breach of charter, and that breach results in another type of loss, that would, in principle, be recoverable in damages in the normal way. Now, in the 1927 decision of the Saga Tin, the vessel was chartered to load a full and complete cargo of timber, and the freight rate varied based on the quantity which was loaded. The loading was protracted beyond the lay days and was completed during the winter season as a result. This meant that the vessel was only permitted to load her winter marks, which was a smaller quantity of cargo. The full and complete cargo was therefore less than it would have been if the vessel had been loaded within the lay days, and the owners therefore received less freight. The owners claimed that lost freight. Charterers said that as the loss resulted from the delay in loading, owners were only entitled to claim demurrage. Now, the Court of Appeal heard in that case that the owner was entitled to recover the lost freight in addition. Now, Lord Justice Atkins said, and I put this quote on the screen because it's not the easiest to read, but I will read it out to you. The provisions as to demurrage quantify the damages, not for the complete breach, but only such damages as result from the detention of the vessel. The correlative to the ship's right to receive the agreed damages is the charterer's right to detain the ship for the purpose of enabling him, if possible, to perform his broken contract and so mitigate any further damage. If, however, for reasons other than the ship owner's default, the charterer becomes unable to do what he contracted to do, namely put a full and complete cargo on board during the fixed lay days, the breach is never repaired. The damages are not completely mitigated, and the ship owner may recover the loss which he has incurred in addition to his liquidated demurrage. So whilst the court in that case did not conclude whether it was necessary to show a separate breach in order to claim damages, following the decision in the Eternal Bliss, we now know that that is the case. Now, very briefly, for completeness, there are also scenarios where a delay occurs before the commencement of lay time or after completion of loading or discharge. Now, unless the charter contains an express provision bringing such a scenario within the laytime or demurrage regime, demurrage is not payable. But absent such provision, any such breach would stand in damages in the normal way. Now I'm going to hand you over to Alex, who will cover a few further topics before we move on to the question session at the end.
Thank you, Sarah. I just want to speak briefly about, if I could have the next slide, please, about dispatch. Now, dispatch is money that a ship owner is sometimes required to pay to the charterer if the charterer completes loading or discharge in less than the allowed lay time. The right to dispatch only arises when it is expressly provided for in the charter party, and it is often considered as a rebate on freight. So the charterer is paid for the full amount of lay time by way of freight. So if he uses less lay time than he's entitled to, he will be entitled to a rebate in respect to the time that he has saved the ship. Now, the lay time definitions for Charter Parties 2013 provide as follows. Dispatch money or dispatch shall mean an agreed amount payable by the owner if the vessel completes loading or discharge before lay time has expired. Dispatch on working time saved or all working time saved or on all lay time saved shall mean that dispatch money shall be payable for the time from the completion of loading or discharging to the expiry of the lay time, excluding any period accepted from the lay time. Dispatch on all time saved shall mean that the dispatch money shall be payable from the time from the completion of loading or discharge to the expiry of the lay time, including any periods accepted from the lay time. So if the clause provides for dispatch in respect of all time saved, the ship owner will normally have to pay dispatch in respect of any Sundays or holidays saved, whereas if the clause only provides for dispatch on all working time saved, they will not. Now, the actual dispatch clause may not be as clear as that, probably won't be as clear as that. So there's a useful summary of the principles involved in construing dispatch clauses was given by Mr. Justice Belhash in the 1913 case of Mawson Steamship Co. and Buyer. Could I have the next slide, please? So he said in that case, accepting, however, as I must and do, the authorities as they stand, I think I may safely say the conclusions to be drawn from them are: 1. Prima facie, the presumption is that the object and intention of these dispatch clauses is that the ship owners shall pay the charterers for all time saved to the ship, calculated in the way in which, in the converse view, demurrage would be calculated, that is, taking no account of the lay-day exceptions. But 2, the prima facie presumption may be displaced, and it is displaced, where either A, the lay days and time saved by dispatch are dealt with in one clause and demurrage in another clause, or B, lay days, time saved by dispatch and demurrage are dealt with in the same clause, but upon the construction of that clause, the court is of the opinion, from the collocation of the words or other reasons, that the days saved are referable to and used in the same sense as the lay days as described in the clause, and are not referable to or in the same sense as the days lost in demurrage. So the lay time and demurrage book, Schofield emphasises that the judge's dictum in that quote there is really just a set of guidelines, and that each individual dispatch clause should be construed individually depending on its particular wording. Now, where dispatch is applicable, it is normally payable at half the demurrage rate, although that does depend on what the relevant clause actually says. Once again, it depends on what the charter party says, but is often the case that the charter party will require separate dispatch calculations to be done at the load port and the disport. But when there is more than one disport, it will not usually be necessary to do separate calculations for each disport. Could I have the next slide, please? So that's the Gen Con 1976 clause 7, and as you can see, it says that the demurrage is payable day by day. So in terms of when demurrage actually falls due, under that clause, the owners have an accrued and enforceable cause of action for the demurrage at the end of every day. However, that position can be altered to postpone the time for payment, and it's quite usual to a lot of clauses say day by day per rata. If I could have the next slide, please. So who is actually liable to pay demurrage? Well, the charter is certainly liable. The bills of lading are really outside the scope of this talk, but just briefly, it appears that it is possible for a bill of lading holder to be liable for demurrage under the charter party terms incorporated into a bill of lading. The editors of Cook on Voyage Charters suggest that where clause 7 of Gen Con 1976 is incorporated unamended into a bill of lading, the bill of lading holders will also be jointly and severally liable for the whole amount of demurrage due under the charter party. However, that particular clause, as you would have seen on the previous slide, does not require any real manipulation to fit it within the bill of lading clause. It refers to merchants rather than to charterers, which can quite easily be construed as a reference to the bill of lading holder. In the House of Lords decision of the Miramar, the court found that clause 8 of the ex-envoy 1969 charter party form was not apposite for incorporation into the ex-envoy bill. And that clause had specifically referred to the charterer being liable for demurrage, and that the House of Lords were not prepared to manipulate the wording of the charter party to bring it within the bill of lading contract. So, in handing down his judgment, Lord Diplock seemingly made it really quite clear that, in his view, creating a situation where the consignee was liable for load port demurrage would lead to a commercially unsound result. So, if I could have the next slide, please. So it is very common to find time bar clauses in charter parties which are specific to demurrage claims. These clauses are very they vary very widely, but usually have the effect of barring claims unless presented within a limited period of time. They often require certain documentation to be produced in support of the presented claim, and their requirements can be quite complex. The clauses are strictly enforced by the courts so long as the wording is clear and unambiguous. So if one is a ship owner or is acting for a ship owner in presenting a demurrage claim, one needs to be very careful to abide by the specific requirements of the particular time bar clause. However, you should note that the clauses will be construed contra preferentum against the party seeking to rely on them, i.e. the charterers. So just to give you some context and explain why demurrage time bar clauses are so strictly enforced, the purpose of time bar clauses is to ensure that the parties, to enable the parties to finalise their accounts as swiftly as possible, and to ensure that if there are any factual inquiries to be made in response to a demurrage claim, that these can be done whilst they're fresh in the parties' minds. Now, just to talk briefly about the supporting documentation, if the time bar clause states that owners must provide supporting documents, but does not specify what documents should be provided, the owners must make sure that they provide those documents which are necessary to support their case on liability, and if relevant, on quantum too. In terms of the documents supporting the quantum, owners will usually need to evidence the period for which the demurrage is being claimed, and provide at least a copy of a valid notice of readiness and statement of facts. And in the case of the Eagle Valencia, which was a 2010 case, there was a 90-day demurrage time bar clause which required any claim to be fully and correctly documented. The first NOR was tendered and had been invalid, but a second NOR that was tendered and was valid. when presenting the claim, the owners only included a copy of the first invalid NOR. The defendant charterers only raised this point after the 90 days had passed, and as such, whilst the owners did then provide a copy of the second NOR after the 90-day time limit had passed, the claim was already time barred. So if, however, an otherwise important supporting document simply does not exist, for instance, if an NOR was tendered orally with no written confirmation, this will not normally preclude a claim from being made. However, on the other hand, in Arbitration 11 of 1990, it was held that a claim was time barred where owners failed to provide the necessary load port documentation. The documentation did exist, but owners did not have it. It was with the vessel's load port agents, whom owners had failed to press to provide the documentation within the time limit. And this decision suggests that it's not enough for owners to omit to provide a supporting document just because they don't have it within their own possession. They must go to reasonable endeavours to procure the documentation. In general, it appears that corrections and amendments to claims which have already been presented can usually be made even when the time limit has expired, so long as all the relevant all the required documentation in support of the revised claim has already been produced within the time limit. Likewise, whilst all supporting documents must be provided within the time limit, there is generally no requirement for it to be provided simultaneously, although we would suggest that it is a good idea to do so where possible. And on the slide, you'll see I've put a good quote from Mr. Justice Bingham, as he then was, from the case of Oltenia, and that summarises a lot of what I've just said. The relevant clause in the Oltenia Charter Party provided that the claim had to be made in writing with all available supporting documents. That's all it said. Okay, so I'm not going to read out that quote, but you've got it there on the slide should you wish to refer to it. If I could have the next slide, please. More recently in the Sabre Wing, 2008, Mrs. Justice Gloucester, as she was then, commented, "The authorities show that parties are obliged to comply carefully and strictly with demurrage time bar clauses of this sort, which are well known in the industry." And I thought this quote is quite useful because it emphasises that whereas the strict interpretation of demurrage time bar clauses may seem quite harsh to even to a non-shipping lawyer, such clauses are a well-known and long-standing feature of charter parties, and experienced vessel operators should know to look out for them. Now, in terms of practical advice, if you are sending a claim with supporting documentation, where possible, make sure that it is received by the respondent and that you have some way of proving this. There have been reported cases where claims have been sent via the broking chain and have not got to the respondent in time and have been found to be time barred. So if you can send the claim directly to charterers, it usually makes sense to do this as well as sending it via the broking chain. But the take-home message, which I hope that I've got across in this part of the talk, is that demurrage time bar clauses are strictly enforced. So owners, if you are bringing a claim, you need to ensure that you've read any such clause carefully and that you abide by it. And charterers should likewise be aware that if owners haven't complied with any demurrage time bar clause, then they may have a ready defence to any demurrage claim. If I could have the next slide, please. So I just thought I'd leave you with one final example of a time bar clause being very strictly construed. In London Arbitration 1 of 2001, the clause specifically required owners to submit certified original supporting documents. They provided copy documents, and the claim was therefore time barred. So that just emphasises that the interpretation is really quite strict. If we've got some questions, I think there were some questions submitted in advance. So if Sarah would like to take the first one of those.
So the first question that was asked in advance was how to calculate demurrage amount if dead freight is incurred. Now, I confess I'm not sure that I've fully understood this question, but for those who need a reminder, dead freight is a sum claimed by an owner against a charterer for failure to load the contractual quantity of cargo. So any demurrage claim under the same charter would be a separate issue and calculated in the normal way. And so that's the demurrage rate multiplied by the time lost. If the question is, does the demurrage rate reduce because of the dead freight, then the answer would be no. The second question submitted in advance was, once on demurrage, always on demurrage, any exceptions to consider? Now, hopefully, I've covered that in the earlier part of this webinar, but just as a reminder, as discussed, it's important in every case to consider whether the charter party contains any exceptions which refer to demurrage, and also whether there's any causative fault on the part of the ship owner. And just looking at the questions that are popping through, Alex, I think there's one here which is for you. The question is, if a charter party requires an owner to submit various documents under a demurrage time bar clause, but the owner knows one or more of those documents is already in the claimant's possession, does the owner need to resubmit it?
Well, I think the answer to that is that owners need to submit all of the supporting documentation, so they need to present it. So they're unlikely to be able to rely on the documents already being in charterer's possession, unless it was owners themselves who previously provided them to charterers. However, the documents do not usually need to be sent all together. So provided owners have provided the missing document to charterers on a previous occasion, they should be okay. But the document does need to have come from owners.
Okay, there's one other question here, Alex, which I think might be for you. You said that demurrage is payable day by day. Can demurrage be prorated for part days?
So it's very common to see clauses saying per day pro rata. Voyage charters, in voyage charters, it's suggested that this wording is necessary to prevent charterers being liable for a whole day of demurrage if any part of the day is used. However, most charter parties that we see, as I just said, do include the pro rata wording. So I've never had to test whether a full day of demurrage would accrue if the words pro rata were not included and it just said day by day. But the case law supporting the proposition in voyage charters is quite old, really. It's Victorian. So it'd be interesting to see what happened if that was litigated these days.
There's a couple more here. Demurrage time bar clauses are obviously something that trouble us all. Alex, I think we can probably take this one together, but if you want to go first, the question is, in case agent were charterer's agent, will owners be liable of time bar due to delay of documents from agent? So I think that question is asking, I think it's the same as the broker point that Alex has discussed. So if documents are sent by owners to charterer's agent, and it seems that the agent hasn't passed those on, will the owners be liable? Now, my understanding is that the agent would be the same as the broker position, but perhaps Alex, you'd like to see if you've got anything more to say about that.
I think with the broker, certainly with brokers, it is that there's conflicting case law. I think that there's potentially an argument that if something is, if the claim is served on the charter as broker, then there is an agency argument that it has been legally has actually been presented. But there's this case law to say the opposite, albeit non-binding, a non-binding arbitration decision. So I think what one has to be very careful. I think where possible, it's always best to make sure it's received by the charterers themselves. And you know, as I said, if you're unsure of one channel of communication, then always best to send it by another as well.
Yeah, I think that the key point on demurrage time bar clauses is act extremely cautiously, because as Alex has said, the case law shows just how strictly these are interpreted. There's a question about detention, and it says how to claim detention after completion of load disport ops when demurrage is not applicable anymore. Can demurrage rate be used? The answer there is that where there is some other delay after loading or discharge has completed, that is a claim for damages, and it will be calculated in the normal way. So all of the rules of causation and remoteness would apply. Now, the rate will be calculated as per normal damages. It could well end up being the same rate as demurrage, but you can't simply apply the demurrage rate. You need to look at the loss that has been incurred as a result of the particular breach in question, the particular delay. So no, you can't simply apply the demurrage rate to that separate breach and for that damages claim. There's one other question here. It's quite a long one, so I'll read it out. Read it out to you all. Where the demurrage time bar clause also expressly lists all the documents to be presented with the demurrage claim, would the claim be considered time barred if all documents from the list are not presented within the stipulated time? And we might want to answer that point, but the question then goes on to say, would the position vary if the listed documents could not be presented because they were unavailable within the stipulated time limit? So, Alex, I'm going to put you on the spot here, I'm afraid, but I think this falls within the areas you've discussed. So the first part of the question is, would the claim be considered time barred if all of the documents from the list are not presented within the stipulated time? I think the answer to that one is probably quite straightforward. But Alex, if you want to take that.
Yes, I mean, as I think I said before, they all need to be presented within the time limit. So even if you think that the charterer already has some of the documents, they all actually need to be presented within the time limit. But if obviously, I would always recommend that you send them all together with the claim. But actually, the case law seems to suggest that if you send them separately or some documents followed by other documents, as long as it's all within the time limit, then that will be okay.
And Alex, are you aware of any cases dealing with the second part of the question, which is what if the documents aren't available? Now, I guess there's a question about what this person means by available. But if we say if a document doesn't exist, I know the availability point is a slightly separate point. I don't know if you want to pick up on that at all.
Yeah, as I think I said earlier, if a document really does not exist, it's not possible to obtain it, then that will not normally prevent a demurrage claim being made. But owners do need to go to best endeavours to locate documents. So if owners merely do not have a document within their possession, they'll need to be able to show that they did go to best endeavours to procure it. Otherwise, there is a real risk that they will be time barred.
Brilliant. That's all of the questions that have popped up. Thank you very much to those of you who submitted questions in advance, and also to those of you who submitted questions just now. It's always very useful for us to sort of see the issues that are troubling you. This brings to an end this 5th webinar. There is one more left in this series in a couple of weeks, so one more of the Voyage Charter series. But to say, everything is available on YouTube if there's anything you want to catch up on. So thank you all very much, and we hope you have a very good day.